The recent Supreme Court ruling represents a significant shift in the balance of power between the executive and judicial branches, particularly concerning presidential actions and the scope of lower court injunctions. While it delivered a major victory to President Donald Trump by limiting the ability of individual judges to issue sweeping nationwide injunctions, the decision did not resolve the fundamental question of the constitutionality of Trump's effort to end birthright citizenship. The Supreme Court's ruling on universal injunctions. On Friday, June 28, 2025, the Supreme Court, with a 6-3 conservative majority, sided with the Trump administration in the case of Trump v. CASA. The opinion was authored by Justice Amy Coney Barrett. Despite her being the most junior justice of the conservative bloc, a move that Chief Justice John Roberts made, seemingly signaling his confidence in her and a desire for continued collaboration. The core of the ruling addressed the practice of universal injunctions, which are orders from U.S. District Court judges that block a challenge policy nationwide, rather than just for the parties involved in a specific case. In recent decades, these injunctions have been increasingly used to prevent arguably unconstitutional policies from being enforced while legal challenges are resolved. Justice Barrett, in her opinion, stated that judges who imposed nationwide injunctions in the birthright citizenship cases had exceeded their authority. She emphasized that federal courts do not exercise general oversight of the executive branch, but instead resolve cases and controversies consistent with their congressional authority. Barrett asserted that while judicial authority is flexible, it is not freewheeling, meaning that if the executive branch acts unlawfully, the court should not overstep its own power. Crucially, the Supreme Court's decision did not address the merits of Trump's executive order on birthright citizenship or its constitutionality. Instead, it focused solely on the scope of relief that lower courts can grant. The administration framed this ruling as a monumental check on individual district court judges, who Trump supporters argued were usurping presidential authority. Judicial dynamics and Trump's agenda. The ruling highlights the solidified alignment of the six-justice conservative majority with President Trump's agenda during his second term. This alignment stems largely from the justices' own desire for expansive executive authority, affecting areas such as migrant deportations and the firing of independent agency heads. Beyond birthright citizenship, the majority has also adopted Trump administration positions on other social policy issues, including siding with religious parents regarding LGBTQ books in schools and upholding state bans on gender care for trans youths under 18. Initially, both Chief Justice Roberts and Justice Barrett had shown wariness towards Trump. Roberts had chastised Trump early in his second term, implicitly rebuking him in March for a social media post calling for a federal judge's impeachment. Barrett, in May 2025 oral arguments, had pointedly questioned the administration's top lawyer, D. John Sauer, about whether the administration would adhere to all court orders. However, this public wariness was fleeting, culminating in Barrett authoring the opinion that dissolved a key check on the president's executive power. Trump, for his part, publicly thanked and praised Justice Barrett and the other majority justices, calling Barrett's decision brilliantly written. This contrasts sharply with lower court judges who, in the early months of Trump's second presidency, had blocked dozens of his executive orders and commented on his larger quest for power. Dueling statements and the dissent. The Supreme Court's decision on Friday played out dramatically with dueling statements from Justice Barrett and dissenting Justice Sonia Sotomayor. Sotomayor, the senior-most liberal justice, passionately voiced her objections from the bench for 20 minutes, twice as long as Barrett. Oral dissents from the bench are rare and are used to convey urgent opposition. Sotomayor condemned the majority's decision for kneecapping the judiciary's authority to stop the president from acting unconstitutionally. She argued that the ruling effectively created a new, unchecked freedom a president would now experience, declaring, "No right is safe in the new legal regime the court creates." Sotomayor deliberately shifted the focus to the merits of Trump's drive to undo birthright citizenship, referencing the notorious 1857 case of Dred Scott v. Sanford, which held that black people could not be citizens, and noting that the 14th Amendment was ratified to remedy that court action. Joined by Justices Elena Kagan and Ketanji Brown Jackson, Sotomayor expressed disdain for the administration and their conservative colleagues, contending that the majority's decisions encourage the administration to defy lower court orders. The issue of birthright citizenship. Birthright citizenship is a long-standing legal principle in the United States, meaning anyone born in the U.S. is an American citizen. including children born to parents who are in the country illegally. This practice dates back to soon after the Civil War, when the 14th Amendment was ratified in 1868 to ensure citizenship for black people, including former slaves. The Citizenship Clause of the 14th Amendment states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside." The Supreme Court explicitly ruled in the 1898 case of Wong Kim Ark that this amendment grants citizenship to anyone born in the U.S., regardless of their parents' legal status, with only a few exceptions like children of foreign diplomats. President Trump's executive order, signed on his first day back in office in January 2025, seeks to deny citizenship to children born to parents in the country unlawfully or on temporary visas. Trump and his supporters argue that the phrase "subject to the jurisdiction thereof" in the 14th Amendment allows the U.S. to deny citizenship to such children, viewing birthright citizenship as a magnet for illegal immigration. However, several lower court judges, including U.S. District Judge John Kokenauer and U.S. District Judge Deborah Boardman, had blocked this order, finding it blatantly unconstitutional and noting that no court in the country has ever endorsed Trump's interpretation. What happens next for birthright citizenship? Despite the Supreme Court's ruling on universal injunctions, the legal battle over Trump's birthright citizenship order is far from over, and its ultimate fate remains uncertain. The High Court's decision sends the cases challenging the executive order back to the lower courts. The executive order will remain blocked for at least 30 days while lower courts and the parties involved determine the next steps. Immigrant advocates have vowed to continue fighting to preserve birthright citizenship. While nationwide injunctions from individual judges are now limited, it remains possible for groups challenging the policy to seek nationwide relief through class action lawsuits, although obtaining such relief is described as difficult due to hurdles courts have imposed over the years. Opponents of Trump's order warn that without nationwide relief, there could be a patchwork of policies across the states, leading to chaos, inequality, and fear. Justice Sotomayor urged lower courts to act swiftly on requests for relief and adjudicate the cases quickly to enable prompt review by the Supreme Court, especially in cases challenging blatantly unlawful and harmful policies like the citizenship order. The ruling, combined with a previous decision granting the president substantial immunity from prosecution, amplifies the power of the American presidency more than ever.